All right, let's proceed.
May it please the court, my name is Terry Hamilton, and with me this morning is Andrew Imbriglio, and together we represent the defendants' appellees in this matter, Hingham Center and Eileen Richards. We are here this morning following a split decision of the appeals court in which two of the three justices actually hearing the appeal determined that the Superior Court judge below, in granting summary judgment in favor of the real estate brokers there, was correct. In that, number one, they did not owe a duty to verify compliance, and number two, the terms of the purchase and sale agreement precluded any claim for misrepresentation.
You got a double negative here, don't you?
You certainly have a double negative. I believe you're referring, Your Honor, to the warranty and representation clause.
Yes.
Yes. I think all of us can agree that it's probably not the most clearly drafted clause that could have been included.
And it boils down to how we interpret that clause, right?
Certainly one of the determinative factors here is that interpretation. But I would suggest to you that in interpreting that particular clause, that probably the most significant words there are the words "except for" at the very end of the clause, which I believe, and others who have looked at this clause, including the treatises and handbooks that the amicus curiae cited to, is that that is the opportunity for the buyer or the other parties to the transaction to specifically list any warranties or any representations.
Well, it says not any, it says additional. Additional to what? So
Additional to any warranties or representations that may be contained in the purchase and sale agreement itself. Because when we look at that purchase and sale agreement, we look at it in its entirety. And in addition to the warranty and representation clause, there are two other clauses there that I would point out to the court are quite important. And one of those is the acceptance of the deed and what that means, and that anything that preceded that is merged into the acceptance of the deed, and most importantly, the integration clause, which essentially says that this is a single final document.
Well, it does depend on how you view that particular clause. If it wants to preclude oral arguments, oral agreements about what's or not oral arguments, then it would. I mean, I do tried very hard to read it your way, but it's actually also pretty easy to read it the other way, which is that we relied upon warranties we haven't relied on anything that isn't in the following, in this agreement or previously made in writing, except for so you've got those two, right? And in addition, we'll put some others down below, and there was none. So if you have, if elsewhere in the agreement says, yeah, this agreement is what we're going to go by, that agreement includes this clause. So I think we really come back to how we have to interpret this particular language. Now,
yes, and the position that I'm adopting in advocating before this court is, I think, the common sense and logical one that was put forth by Justice Meade, and with whom the Chief Justice joined in the appeals court opinion, that the logical way of reading that clause is to look at it from the point of view that the except for clause is the clause that is important, and if there were any warranties or representations beyond those that are not listed in the purchase and sale agreement, they ought to be set forth in this particular agreement.
Doesn't it say, isn't the word subsequent in there? Except for any, or did I write
Following
it down?
additional,
Any additional?
the following addition.
That he has not relied upon any warranties or representations not set forth
Yeah.
or incorporated in this agreement.
Except for any additional ones?
No, it doesn't really say, I don't believe, Your Honor, it says additional ones.
It says-
I'm sorry, it says
does.
except for the additional ones.
Right,
And there are no further additional
Correct.
ones.
But it's
set
or
forth.
previously made in writing.
right.
Or previously made in writing, except for the following additional warranties and representations. So there's that other clause in there, or previously made in writing.
So what do we do with that one?
Well, that's,
Again, all I can tell Your Honor is to go back to what Justice Meade and Chief Justice Reposer said, that there are, that the interpretation of this is that there are two types of warranties that the buyer is not relying on or has not been influenced to enter into this transaction.
But was there a description of the property on a sheet of paper describing the property that included words to the effect that it was zoned Business B, I think it was? Was there anything in writing describing the property? Not in the purchase and sale agreement. Was there any written submission that was given to the prospective buyers that indicated that the property had been zoned Business B?
The only thing that was given to the buyers was, as the real estate broker described in her deposition, after she gathered this information from the seller, she put a listing sheet at the property for all prospective purchasers. And that listing, among many other things,
But it
among
did
many
say-
other items of information,
So why
said
isn't-
that the property was zoned as quote-unquote Business B,
Yeah.
which was information that she had obtained from the seller.
but it was in writing, that's the,
It
wasn't right?
absolutely
So why
wasn't right.
isn't that incorporated into the purchase and sale agreement by virtue of that clause?
I think it is incorporated into the purchase and sale agreement to a certain extent, but when you read the rest of the agreement, including the addenda and the rider, you see other clauses which grow out of that initial representation that was included in the listing sheet. For example, if you take a look at Rider B and Clause 7, it says, "This agreement is contingent upon the buyer obtaining all necessary permits from the town of Norwell on or before November 16, 2004, to accomplish the purposes that have already been agreed upon."
So let,
Those,
go ahead.
those purposes had to do, or had to do with the buyer's ability to
Convert it to the business he wanted to
convert it to a six-station hair salon.
So
It
let me
was an
ask-
implicit recognition by the buyer that notwithstanding the representation that this was zoned Business
Mr.
B.
Hampton, he got a building permit thereafter, so.
Pardon?
He got a building permit to do just that thereafter, so why, if he'd gotten that before, would it have told him anything?
No, he did not get the correct building permit.
He
The
got it-
building permit that he got only allowed him to build a two-station hair salon. He wanted a six-station
He got
hair
something
salon.
before he got the building permit.
I'm sorry?
He got a permit to, I think, to increase the amount of, there's something he got, but that wasn't. the
Well,
building.
he got the building permit simply because
That's something
at
else.
that stage, it was a two-family residence. And he had to build it out into a hair salon. So just by virtue of the fact, it didn't really matter whether he was making a two-chair hair salon or a six-chair hair salon. He had to obtain a building permit.
But what did he get the building permit for? Did he get it for 2 or 6?
We don't know. It's not in the record. But at some point, after he began building, the building inspector came in and said, "What are you doing?" And he said, "I'm building a six."
I thought he got, I had from memory that after the date, admittedly after the date that was in the purchase and sale agreement, he obtained a building permit to build 6-station salon. No?
That is not in the record. I've never seen it in the record, Your Honor.
Okay,
There is no building
sorry.
permit in the record. But the important point is that even though this representation was made that it was zoned Business B, that's just the very beginning of an inquiry as to what you might be permitted to do and how you can use the property.
Can I ask you a question? If the appeals court majority's interpretation of the warranties and representations clause is correct, if you just assume that for a moment, that's not your position, but let's assume that the majority was correct. Is that dispositive on the question of summary judgment? Or is there some way that the defendant can still prevail as a matter of law?
Sure, because the other point that I wanted to argue this morning had to do with, I believe that the majority decision in DeWolfe is a substantial departure from the appeals court's earlier decision just 3 or 4 years ago in Quinlan versus Clasby, in which the court said, and there was no split decision there, that a real estate broker had no duty to verify compliance with zoning laws. Now, in that particular case,
But does that make any difference if even if there's no duty, if the representation is made and if it becomes merged into the purchase and sale agreement, regardless of the existence of a duty, isn't the seller bound?
I do not believe this, I don't know about the seller. I'm representing the real estate broker here, the seller's agent. But I don't believe that binds the seller, because under existing case law, not only Quinlan versus Clasby, but also the Fernandez versus Rodriguez case, an innocent representation.
This is a written representation that is absorbed into the purchase and sale agreement by the terms of the purchase and sale agreement.
But, Your Honor, I'm saying that it is still an innocent representation on which, under existing case law, a real estate broker is entitled to rely, because it's reasonable information passed along by the seller to the broker. The broker is simply a conduit, a conveyor of information. In addition to a representation as to the zoning classification of the property. If you take a look at that listing sheet, there are numerous other items on there that we all know that a broker doesn't have an opportunity to go back and to be able to verify. In this particular case, the buyer had his own broker. He had his own attorney, who, by the way, included this language not only in the P&S agreement, but also in the offer that preceded it. He had the ability, if it was a matter of importance to him, a phrase that this court has used many times in residential and commercial real estate transactions, he could have verified it.
So let's go back to Justice Link's question, because it's puzzling to me. Let's assume we agree with the majority. Are there issues with respect to causation or reliance or waiver that are alternative bases for you to win on summary judgment?
Well, sure. As we pointed out in the brief, even that representation that it was zoned Business B, even if it had been true, Mr. DeWolfe, unfortunately, still would not have been able to build his 6-station hair salon, because, as I indicated earlier, the classification of the property is simply the very beginning of what type of use you can make of that property.
He couldn't have built it and lived in it, isn't that right?
I'm sorry?
Isn't the problem he couldn't have built it and lived upstairs?
Absolutely. Absolutely. And that brings me back to another essential fact in this case, is that prior to even starting to look for a property for his hair salon, Mr. DeWolfe obtained a residential, a pre-approval for a residential mortgage. So this was a place that he was looking to live in and to also operate his business. So regardless of any representation that may have been made by the real estate broker, be it oral or written, he still wouldn't have been able to do that. Finally, I would just like to add, and this is all set forth in the amicus brief, this is really requiring a real estate broker to give a zoning opinion, something that
Well, they don't
really
have to.
is a matter of practicing law, is this court recently recognized in the Real Estate Bar Association case, it is determining the rights and the liabilities of an individual.
Isn't it
Real
only
estate
saying that they're not supposed to give that? I don't think this requires them to give the zoning opinion. I think it says if you shouldn't. You should say you're not giving a zoning opinion. You should say where you got this. I only asked, I'm not telling you. Instead of saying, yes, this is resident, you can do this. You shouldn't say, you shouldn't look like you're saying. Isn't that really what this stands for?
That might not be a bad idea, Your Honor, but I would point out in that respect that in addition to saying it was zoned Business B, they also made representations in there that it was located in a commercial district, that it could be a lovely two-family home, et cetera. It was, again, one of a myriad of representations that are made in there, and then most importantly, the bottom line, there's a disclaimer in there saying this information came from other sources, and that if someone wants to verify it, they're free.
Mr. Hamilton, you're out of time, but I just have one other question. Are you saying that the purchase and sale agreement and that merger clause that's in it is actually completely irrelevant to the claim against your client? Because the claim against your client, the broker, really rises and falls on whether or not there is a duty on the part of the broker to report accurately anything having to do with zoning.
Well, at its heart, this is a negligent misrepresentation case, so it's really a tort case. Yeah. I wouldn't say that the purchase and sale agreement is irrelevant, but viewed in its entirety and interpreted the way that the minority in the appeals court did, it would actually support the proposition that the real estate broker has no duty to verify compliance with zoning laws.
All right,
Could I ask
Counsel.
one other, I'm sorry, one question? If the language is ambiguous, does that, is that a problem for the seller and broker as opposed to the buyer? I mean, it's a Greater Boston real estate form, right?
It is a real estate form. I don't think in this particular case the ambiguity favors one side or the other, simply because of the except for clause that gives that buyer the opportunity to put in what representation he or she is relying on.
Your time is up, sir.
Thank you, Your Honor.
Chief Justice Ireland and members of the panel, my name is Lawrence Rose. I represent Daniel DeWolfe, who is the appellant and plaintiff. I believe the reason that we are here is because there was a dissenting opinion. We don't have a unanimous decision out of the appeals court, and the dissent was based solely on the exculpatory clause in the purchase and sale agreement. We start with a Superior Court summary judgment decision in which Judge Healy bases his decision primarily upon the case Quinlan versus Claspy. Both the majority and dissent in the appeals court agreed that that was a misreading of that case, that Quinlan versus Claspy is a case that deals with general duties, not a case that deals with misrepresentations. However, in a dissenting opinion, Justice Meade, joined, I believe, by Justice Raposa, interpreted the exculpatory clause in the purchase and sale agreement differently. And they said because of that...
Before you leave that, let's turn back to that. Is it your position that if a broker passes on information from the owner of the property, that the broker then is responsible for the truth of all that is said, even if that basically there's no issue of duty once a broker passes on information from an owner?
That is not my position, and I want to be very clear about that. This is not a case where the broker was passing on information provided by the seller. The seller denied ever having told the broker that the property was zoned Business B. And looking at the facts most favorably to the non-moving party in a summary judgment motion, that fact has to be accepted. In addition, on page 121 of the appendix, you'll find the real estate broker's own notes when she took that information. And in her own handwriting, she wrote "at-home business." So that supports the seller's statement that they never told her it was zoned Business B. So this is not a case.
So your point then is that even if we accept the proposition that a broker owes no duty to verify a zoning information provided by the seller, that there's still an issue of fact here as to whether the zoning information provided came from the seller.
Yes, that's an issue of fact. I'm not sure it's dispositive of the case for other reasons, which I'll get to, but as I said, since the seller denies ever having said that, the broker's own notes support the seller's version, and we have to look at the facts in the light most favorable to the non-moving party, then the fact that would support any decision of the Superior Court in summary judgment or of the Appeals Court or SJC is that the seller did not tell the broker that the property was owned Business B. And so we should not be deciding the case on that basis.
The broker was not a party to the purchase and sale agreement.
That's correct.
So why is the purchase and sale agreement being used as the fulcrum for the decision in this case? It's a question of duty, isn't it? And whether the broker, was there a duty, and did the broker breach that duty?
Well, the broker is held to the same standards as every other person doing business in the Commonwealth of Massachusetts. Now, we have an amicus brief, as well as the defendant, who would have this court give greater protections to real estate brokers than are given to anyone else who does business in the Commonwealth.
Why do you say that? I mean, well, the brief says, look, this form has been used for 30 years, and there's an expectation in the industry as to what it means, and the majority just simply has it wrong. That's not what it's intended to mean. Why is that favoring one party versus another?
Well, we're talking about two different things. The exculpatory clause is one thing, but as far as duties, the broker's duties are the same as anyone else's. And if a broker makes a representation of fact, they have an obligation to take reasonable efforts to verify the truth of that fact. And in this case, we have a broker who made many representations concerning zoning without ever checking the zoning, without ever verifying them, and where that came from, whether she simply misunderstood or her brain did a flip and she suddenly decided it was Business B, it didn't come from any source. So she violated her duty of verifying the truth of the information. And that stands.
So is this a negligent misrepresentation? Is that what we're talking about here?
It could be. Now, I understand the dissenting opinion says that we've only pleaded negligence. I disagree with that. My complaint sets out the misrepresentations very carefully and in detail, and then says that they were false, that the defendants knew or should have known they were false.
So are you saying it's intentional?
It could be. I don't have evidence that it was intentional, but I think there is evidence that it was reckless because she made numerous representations about zoning, not just that it was zoned Business B. She also provided a written paper showing the allowable uses, which said hairdresser. She also told Mr. DeWolfe in no uncertain terms that he could put a 6-station hair salon in this location. She had no basis for any of these statements. She didn't check the zoning laws. She had no expertise in zoning, even though she held herself out as such. She didn't check any public records. And she just made all these statements without ever, not only not verifying the truth of them, but without ever even trying to ascertain whether they were true or not.
So if the seller in fact did say that it was zoned business B, if the seller had said that the oil burner was replaced, or the gas burner was replaced 8 years ago, that a new roof was put on 4 years and 1 month ago, and that all goes into the listing statement, are you saying that a broker has to verify all that information? Or they're on the hook?
If the statements are reasonable, and it's reasonable to rely on those statements, the broker does not, and that's the law in the Commonwealth. But that's when the information is simply being passed from the seller to the broker, who then relays it to a buyer. If that were the case, this would be a very different case. But as I said, the seller never told the broker that it was zoned business B, so that's just not our case. In this case, the broker took it upon herself to make statements. I'd like to mention the disclaimer in the MLS listing. If you read the disclaimer in the MLS listing, it doesn't just say the broker's not responsible. It says the information in this listing was gathered from third parties, including the seller and public records. That statement, which is meant to be a disclaimer, in fact says in plain English that the broker checked the public records, including the seller and public records. This real estate broker never checked the public records. She didn't check any zoning records at all. The only thing she did was she went to the zoning board and obtained a portion of the ordinance showing the allowable uses in a business B, and then she put that on the kitchen table and, of course, pointed it out to Mr. DeWolfe, which was intended to let him know that he could put a 6-station hair salon in the property. But she never checked any public records for any zoning requirements, contrary to what it says in the MLS listing sheet. So Mr. DeWolfe believed that this real estate broker, who was experienced, a professional, licensed person, and by the way, Mr. DeWolfe is a hairdresser with a high school education. He knows nothing about zoning, but he believed that he could rely on what this person told him.
Did he have a lawyer and a broker?
Yes, he had a buyer's broker, and he had an attorney named Mr. Hodgson, but he went to the attorney simply for help preparing the purchase and sale agreement.
And the attorney actually put in there that this was all contingent on permits being obtained for the purposes which your client said he wanted to use the property.
No, if you read it, it says it's contingent upon obtaining a permit. The permit that Mr. DeWolfe understood he had to obtain was for a septic system. A hairdresser uses dyes and other chemicals in his business, and you can't put them in the sewage system. So a hairdressing salon needs a tight tank septic system to deposit those chemicals. And he knew that. He was an experienced hairdresser, and he knew he needed that permit. And in fact, he obtained that permit before the closing took place. And that was the permit that he was concerned about. That's why that was in the purchase and sale agreement.
Is there anything in the record that, through discovery, that indicates why whether there was any consideration given to putting into the purchase and sale agreement a specific condition that he get or that the property qualified under zoning, applicable zoning, for a 6-station hairdressing studio?
No, that's not in the purchase and sale agreement.
Okay, but had it been, was there any consideration given as to putting it in the purchase and sale agreement according to the record?
Not according to the record. There's no evidence one way or another whether there was a negotiation on that. I suspect there was not. As I said, Mr. DeWolfe believed Eileen Richards. He relied upon her. She told him how it was zoned. She put it in writing. She told him he could put it in his 6-station hair salon. He did not ask his attorney for zoning advice. He did not believe he had to ask his attorney for zoning advice.
So if we interpret the P&S differently, if we interpret it consistent with the majority, do you lose or do you still have a claim?
You mean consistent with the dissent?
Yeah.
With the dissent, I'm sorry, yes.
I'm glad you asked that. I still have a claim, and I'll tell you why. If you interpret it the same as the majority, I think that's well warranted, because that's how it's been understood for years.
No, I take the dissent.
Right.
Right.
And that's how we understood it.
But which
and
way
that's how
is
it
the way you, I'm sorry, I got lost in
The
majority.
majority
dissent.
says that the exculpatory clause does not preclude
Okay.
warranties previously made in
You say
writing.
that's the way it's been understood for years, but that's not what the Greater Boston Real Estate Board says.
Well, that's what they say in their brief, but let's take a look at the appeals court decision. In the first place, they refer to the case of George versus Tier.
I'm sorry, go back to Justice Corey's question. Okay, so let's just say you go with a minority. You don't lose because.
Okay. In 2000, Justice Gantz, sitting in the Superior Court, decided George versus Tier, where he said, I read this as not precluding representations previously made in writing. If you look at page 8 of the appeals court decision, they note that the defendant did not even argue for the dissent's construction of that clause. So it perhaps didn't even occur to the defendants to argue for that construction. Certainly we understood it as meaning what the majority says, and 3 justices of the appeals court understood it that way. The definition of ambiguous is a term is ambiguous if it is susceptible of more than one meaning and if reasonably intelligent persons would differ over the proper meaning. And I'm citing a case that's not in my brief. It's Suffolk Construction Company, Inc. versus Illinois, which is a 2011 Massachusetts appeals court case. And I'm sure that definition is not controversial. You'll find it in other cases. So
What's the site on that case?
the site on that case is 80 Mass Appeals Court, page 90, and that quotation is at page 94. So here we have 2 justices say, we interpret it, we give it one meaning, 3 justices, a Superior Court justice, as well as parties who give it a different meaning. If you conclude that the majority is not correct, and I submit that that is the proper conclusion, they are correct, based on the rationale in the appeals court decision, you have to admit that reasonably intelligent people have differed over the meaning of this clause. And if that's the case, then it's ambiguous.
But do you even need the purchase and sale agreement to prevail on a tort theory, on a negligent misrepresentation theory?
I do, because of the exculpatory clause. And that exculpatory clause...
Well, that would be true if you were suing the seller, or the seller of the home. But if you're suing the person that's making the misrepresentation, don't you have a negligence claim against that person, independent of the purchase and sale agreement?
I would like to say yes, but I believe
not
that they
sure.
would be considered a third-party beneficiary of that contract. I believe that clause is there to protect the broker. I'd like to say it isn't, but I don't think that solves my problem. I think the real question here, if we only go with negligence, and I'm not giving up on the reckless or intentional claims, and if those statements made by the broker are deemed to be reckless, then that exculpatory clause does not help the defendant.
Assuming, but going back, if it's just negligence and you've got, we accept your view that at best it's ambiguous, who bears the burden of the ambiguity?
I would, well, to prove that it's ambiguous?
No, it's ambiguous. So who does that mean? I mean, do you say, well, because it's a real estate form, it's really the problem of the broker, or what do you do with that?
I would argue that for a different reason. We have a situation in which one party is giving up important rights, and the other party is benefiting by gaining important rights. And you can't give a party important rights and take away important rights from another party based upon a clause that isn't clear to the party that's giving up those rights. So we're saying, Mr. DeWolfe, you gave up all these rights based on a provision in a contract that we don't even understand. That's just not just. And if we're going to find that it's ambiguous, then you can't, based on an ambiguous clause, take away these important rights from Mr. DeWolfe.
All right, your time is up. Your time is up.
Thank you.
Thank you, sir.